Hi, my name is Mark Belash. I'm president of TorontoEntrepreneurs.ca. Thanks for watching. In this segment, I'm joined by Stuart Rudner, employment lawyer at Rudner Law. Thanks very much for joining, Stuart.
Thanks for having me, Mark. Looking forward to the discussion.
Sounds good. So I come on here and we talk about different topics that might be of interest to, really both employers and job seekers. But I think this time we're going to focus on the employment lawyer. Um, so obviously there's a lot of things that are going on within the pandemic and COVID-19. So just let's talk about bringing workers back, because that's probably what employers are thinking about right now. Who comes back? How do you choose? Is there a way of figuring that out? So maybe from a legal perspective, you can comment on that.
Yeah, absolutely. I'm happy that the discussion has shifted from layoffs to recalls. But the challenge is most companies are not in the business of laying employees off. And so they didn't know how to do that. And a lot of them made mistakes. Now we're talking about bringing the workers back. They don't know how to do that either. And there's so many assumptions and misconceptions out there. People assume you've got to bring people back based upon seniority, or the first one laid off has to be the first one brought back, or I've heard all these different rumors, none of which are true. So I'll make this distinction. If you're unionized, you've got a collective agreement. That will set out a very clear process for layoffs and for recalls. But otherwise, if you're not unionized, you can basically pick and choose who you bring back and when, based on whatever criteria you like, or no criteria other than human rights. So obviously not based upon race, gender, et cetera. And one important point there is, so if COVID-19 is treated as a disability under human rights. So if someone tested positive, let's say back in April, you couldn't choose not to bring them back now because of that. But other than that, employers can pick the ones they want to have back and bring them back first.
So I've had this, and I've come across this situation, especially in this time period, where somebody who has kids can't really come back because they don't have daycare, they don't have their school's not back yet, but an employer might want them to come back. So how do you deal with that? Like, can they refuse to come back? If they don't come back, do they get terminated? Maybe you can just talk about that too.
Yeah, this is a question we're getting a lot of. And again, because this is all so new and it's such an unprecedented situation, and people are now at home and maybe are laid off, maybe, and of course, with the recent regulations, that the layoffs have changed the leaves of absence. There's a lot of confusion there. But a lot of people don't understand that when they are now recalled to work and told you're expected to be at work on Monday, it's not optional. It's no different than it was, back in the pre-pandemic 8 days, if you remember that time. If you went to work on Monday and Tuesday, you couldn't just decide not to go to work on Wednesday. And it's the same thing now. You may have been off on a layoff, but when you're directed to return to work, it's not a choice. And there's really only three exceptions to that. One is if you're entitled to a leave of absence. So most provinces like Ontario have emergency leave if someone is unable to work due to COVID-19. And that would cover things such as if they have to self-isolate or if they have childcare obligations. And I'll stress the word obligation, not preference. It's not that they would prefer to look after their kids rather than having someone else do it. But if there's truly a need, they're entitled to a leave of absence. There's also human rights accommodation. So similar grounds. If, for example, they have a medical condition that makes them more susceptible to the virus, they may not be able to return to work. Or again, they have childcare obligations. You may have to accommodate them. Again, accommodate, though, doesn't necessarily mean letting them stay at home. Maybe you can accommodate them by having them work from home or change their hours so they can adapt to the childcare obligations. It's not just a matter of them saying, I can't come to work, and you saying, okay. You can explore the options. So those are the first two exceptions. The last one is the right to refuse unsafe work. If there is a legitimate concern that the workplace is unsafe, not that it's unsafe to go out in public or anything like that. If the workplace is unsafe, someone can refuse to work, and then you get the Ministry of Labor involved. But those are the three exceptions. And unless they fall within one of those, then they have to return to work. And if they don't, you can essentially deem them to have abandoned their job. The one thing I'll add to that is a lot of my clients aren't ready to bring back 100% of their workers. So they're actually quite happy when some people say, look, I can't come back for now. And so if that's the case, you can just agree that they will stay on a leave of absence. So think about that before you take the aggressive approach. But if you do need them and they say no and they don't fall within the exceptions, you can say you're going to be deemed to have abandoned your job and you will lose your employment.
And is there a rule of thumb, like how much notice an employer needs to say, you have to be back by Monday, 2 weeks notice or 1 week, or is there anything like that out there?
Yeah, generally speaking, no. I mean, every province, and it's important to remember, employment law is governed provincially. So every province has its own set of legislation. And so they're similar but different, but most of them just provide for a reasonable notice. And the thing to remember is if you're on a layoff, you're expected to be generally available. You're not supposed to be off, well, nobody's off in Europe these days, but you're not supposed to be traveling. So you're supposed to be available. So we're talking about a matter of days, not weeks, to return to work once you're recalled.
Gotcha. And what are an employer's obligations in terms of preventing the spread of the virus in the workplace now? Like, is there anything in stone? Is there? It seems like companies are just kind of making their own rules up and just making sure that the employees are safe. But is there anything required?
Yeah, well, I mean, I think you're right. Everyone's trying to figure out what to do. You start with the proposition that every employer has a duty to take all reasonable steps to provide a safe workplace. That's a pretty general obligation. And obviously that includes taking steps to prevent the spread of the virus. But what you have to do specifically, it's case by case. So we're telling our clients, listen to the medical authorities. The Ontario government put out a great guide, and it's divided by industry. And I think there's about 70 different sectors they cover. That's not law, but it's certainly persuasive. So I would look at that. And if you're not going to follow that, you should be prepared to explain why. But the other thing we tell our clients now is, if you have a health and safety committee, get them activated, get the people involved in health and safety activated. Think about the risks in your workplace. Think about the nature of the workforce. And it's not one size fits all. So some of our clients have some employees who are going to stay at home and work from home. And that's still the preferred method of reducing risk. Others have to be in the workplace, but they can be physically distant. And our clients have reconfigured the workplace, and they put barriers or at least tape on the floors to make sure people stay apart. Others have to have closer contact, either with their colleagues, with clients, customers, suppliers. So PPE becomes very important. So what will be required in any given circumstance will depend on that circumstance. It's got to be all reasonable steps. And like I said before, if an employee feels as though it's unsafe, they can call the ministry. And I can tell you the ministry has already received thousands of calls, but very few of those complaints have been upheld. In most cases, the ministry has found that the workplace was safe.
Okay, awesome. So we just have another 30 seconds here or so. So how can someone get hold of you if they wanted to talk to you about a particular situation in their organization?
Yeah, best way to find us is on our website, rudnerlaw.ca. It's RUDNER, law.ca. Feel free to reach out, and if we can help, that's great. And the last thing I will say is I spent far too much of my time recently putting together a guide on getting back to business. It's about 30 pages. It's like an FAQ, so it tries to answer all the questions we're getting from employers and employees. So feel free to go to the website or email me, Stuart@rudnerlaw.ca, and we'd be happy to send you a free copy.
Thanks very much, Stuart. My name is Mark Blaish. I'm president of TorontoEntrepreneurs.ca. Thanks for watching. And feel free to connect with me on LinkedIn as well. And Stuart, you're on LinkedIn too. I'm sure someone can reach out to you as well. So
Absolutely.
Thanks very much, Stuart, for your time, and take care, be safe, and be well.
Thank you. Stay safe, everyone.